America's center of power changed, and with it, the dynamics of the political landscape. The consequences will reverberate locally, in Florida, on Capitol Hill, and on the global stage. Voters demanded change on the issues that mattered most: the economy, immigration, and social issues. Now, News4JAX goes beyond the headlines with political analysts who provide unique context and perspective. Experts focused on the issues making headlines. This is Politics and Power.
This week on Politics and Power, the U.S. Supreme Court jumping headfirst into turbulent waters with issues that have become politically divisive. The 18th century wartime authority to speed deportations, known as the Alien Enemies Act, is back in the High Court's hands. Can the Trump administration circumvent the court and continue with deportations of illegal immigrants by employing other laws? And how will the justices review that request? Also on the High Court's docket, what's the extent of lower court judges' power to block a president's policies nationwide? How the justices' rule could dramatically impact how Trump's policies are applied across the country. And a case that could rescind no-cost preventative health care mandated under the Affordable Care Act before the court. It could impact tens of millions of Americans benefiting from the program's health plans. Welcome to Politics and Power. I'm Bruce Hamilton, and joining me, constitutional law expert Rod Sullivan. Appreciate you being here, as always.
Good to see you.
So, let's start with the 18th century wartime authority to speed deportations, known as the Alien Enemies Act. It's back in the High Court's hands. So less than 2 weeks after the Supreme Court allowed President Trump to employ the controversial authority, the issue was literally rocketed back to the justices in what's best termed as a short fuse appeal. The consequences here are enormous. What's really at issue?
Well, you know, the word short fuse is really well stated here, because the justices got this motion to stay at 4 o'clock in the afternoon on a Sunday. 8 hours later, without receiving any briefs from the United States, only the briefs that came in from the ACLU, the Supreme Court said, nope, we're going to stop your use of the Alien Exclusion Act until you have more of a hearing. And 2 of the justices dissented from that, mostly on procedural grounds. They say, you know, we don't normally do this. We don't jump ahead of other courts and tell them they can't do this. And the Trump administration has stopped those deportations. So the question is, you're asking me, is are there other acts under which they can continue to deport people? And there are. The only thing about the Alien Exclusions Act is that it basically limits judicial review to the constitutionality of the act and questions of law. Questions of fact are not before the court. But what the court is, I'm reading between the lines here, but I think what the court is saying is we're going to look at this issue of whether or not MS-13 and Tren de Agua criminals coming across the border into the United States constitutes as an incursion on U.S. territory by a foreign government. And I think the facts are probably not in favor of the Trump administration on that. I mean, there have been criminals coming into the United States from many nations for years. Whether you talk about, you know, La Cosa Nostra, or you talk about, you know, alien terrorists and the like, and nobody's ever used this act before to interrupt their coming into the country. Trump decided to do it with regard to these two gang groups, MS-13 and Tren de Agua, and has been successful so far in getting somewhere between 150 and 300 people out of the country. But I think probably the Supreme Court is going to put a stop to that. But remember, Obama removed 3 million people without using the Alien Exclusions Act at all. The Immigration and Nationalization Act gives a lot of power to INS to remove people who are illegally in the country. The only difference is that there's a little bit more judicial review. There's the chance to appear before an administrative law judge within 35 days of detention and things like that. But there's broad powers out there to remove, quote unquote, illegal aliens or undocumented migrants, as you call it. So yes, I think the Trump administration is going to be able to continue to remove people just using the standard INA authority. Another thing they're doing is these asylum petitions. You know, normally you would think a petition for asylum goes in and the oldest one gets heard first. Trump said, no, we're going to hear the newest one first. If you file a petition for asylum today, your asylum petition is going to be heard first. And consequently, it's really sort of shut down this asylum process, because the asylum process takes 5, 7, 10 years to go through the entire process. By Trump saying, okay, we're going to take the newest petitions first, they're able to like triage the whole system. We're going to say whether this case has some possibility of it succeeding, a minimal possibility, or no chance of succeeding. And if it's no chance of succeeding, you're out of here. So those are the kind of things that are within the president's discretion to do, which is going to enable them to continue with the deportations, even without the Aliens Exclusion Act.
You know, I think, you know, the reality is that the system is broken and nobody's ever found a way to fix the system. And Congress needs to get to that, but that's a whole other issue. So in the interim, back to what the justices are doing. They issued this overnight order with the majority blocking the Trump administration from deporting a group of immigrants in Texas. Two conservatives, Justices Clarence Thomas and Samuel Alito, dissented from the decision. Possible the court would allow the administration to use, as I said, other laws to skirt the Alien Enemies Act altogether?
Absolutely, yeah. All of these other authorities still exist out there. There's a lot of different bases. I mean, you can go back to the 1918 Immigration Act, which allows the government to exclude anybody who advocates for the violent overthrow of the government. President Wilson in 1918 and 1919 excluded 13 million aliens based upon no criminal convictions. They were here in this country, but they were either members of the Communist Party or they were anarchists who advocated the overthrowing of the government. And so that power is still out there. The Immigration Naturalization Act is still out there, allowing removal and return. So there's a lot of bases for people to do, for the Trump administration, remove aliens. This one particular tool has less possibility for judicial intervention, but the people that are deported under the INA, they're still going to go before an immigration judge, an administrative law judge. They're still going to be able to appeal to the Board of Immigration Appeals, and but then most of those cases are resolved, and those people still are deported.
Yeah, we can't ignore the fact that there are other cases playing out in what, New York, Colorado, Texas. So the question is, you know, with all these other cases, where does everything land?
Yeah, well, we had this discussion before. It's like trying to drink from a fire hose. To figure out where all these cases are and all these issues are, it's very difficult. But the fact is that the lower courts are going to take guidance from the upper courts, the appellate courts, and the Supreme Court as they decide these issues, and that's going to allow the lower courts to make decisions that will not be appealed or overturned on appeal. All
right, speaking of lower courts, let's move on to another momentous question before the High Court. What is the extent of lower court judges and the power to block a president's policies nationwide?
You know, I don't often make predictions, but I'm going to make one in this case. This question of nationwide injunctions has been percolating along for many administrations. You know, we have U.S. district courts throughout the entire United States, over 1,000 judges. And each one of those judges feels like if they get a case, they can issue an injunction that applies not only to the parties who are before them, but to everybody in the United States. So right now, there are hundreds of injunctions out there that affect you and me. Even though we're not parties to the litigation, we have no opportunity, we have no notice, no opportunity to be heard. And the courts are saying, yeah, I'm going to enjoin the government from doing this to these small group of 3 or 4 people, but I'm going to apply it to everybody in the nation. And that's what was done in, for instance, these Tren de Agua cases. Aragua, TDA, for lack of a better word. 4 plaintiffs brought a case in the Washington District Court, United States District Court in the District of Columbia. Judge James Boasberg got the case and said, yeah, I don't think these 4 people should be deported, and I'm going to prevent you, the federal government, from deporting anybody in Tren de Agua nationwide. And so that got taken up on appeal. And this is why I'm able to make a prediction about what I think is going to happen, because the Supreme Court came and said, look, you have 4 parties before you. They have attorneys. You have the United States in front of you, and you're in the wrong venue. Those 4 people are confined in Texas, so the case doesn't belong in the District of Columbia, so it's going to have to go back to Texas. And you're not going to be able to issue an injunction that applies to the entire nation, Judge Boasberg. Judge Boasberg got his fingers slapped by the Supreme Court very publicly. And so the case immediately went back to Texas, got refiled, and it's going forward. The other thing, as the court said, is you, Judge Boasberg, don't have jurisdiction over this case. This can only be brought as a habeas corpus proceeding. Now, the important thing about habeas corpus is it's control over the body. So you have 4 bodies in front of you, and you can issue decisions with regard to those 4 bodies, but not the entire world, because the entire world is not in front of you. The entire world doesn't have an opportunity to hear about this case, appoint an attorney to represent their interests. Therefore, it's only going to be heard with regard to these 4 people under habeas corpus. And so that has, in my opinion, signals what the court's going to do with this nationwide injunction procedure. And the Biden administration complained about nationwide injunctions. The Bush administration did as well. And I think this is part of the separation of powers argument. The court has been very big on saying, administrative agencies, you can only act with authority from Congress. Congress, you have responsibility in these particular areas, and courts, you have a very narrow obligation under the Constitution. You can hear cases and controversies. A case implies that you have a person who has standing, who is before the court, whose rights you can decide. You can't decide the world's rights. You can decide only the rights of those people in front of you. And I think that's where the court's going to come down. They're going to say, under Article 3 of the Constitution, you, United States District Judge, can hear a case or a controversy. You can't hear everything in the entire world. You can't interrupt the entire operation of the federal judiciary. Are there going to be inconsistencies? Sure. There are going to be judges in Louisiana, Texas, New York, state of Washington who are going to come to different conclusions on these issues, but they're not going to be conclusions that are applied to people who are not before the court. And consequently, it's going to severely restrict the power of federal judges to do what they want to do.
You brought up an interesting point. It's probably getting more play in the news now, more headlines. But, President Biden, his Department of Justice asked the justices to limit lower courts' nationwide injunction powers as well. Without nationwide blocks, could some policies, like birthright citizenship, be put on hold in certain states while allowed to take effect in others as litigation plays out? And does that raise questions about uniformity?
It does, but here's how that's supposed to be handled. If a case arises in the 11th Circuit, which is our circuit here in Florida, and another one arises in the 9th Circuit out in California, and the results are different, they go up to the appellate courts. And those appellate courts look at the competing orders and decide which one is right. And then if they're in conflict, it goes up to the Supreme Court. So you're still litigating on behalf of actual people that are before the court and defending their particular interests. You're not interrupting the entire federal government from taking action. So yes, there will be inconsistencies, but these are inconsistencies that occur in every litigation. It's not unique to the question of immigration.
All right.
And as the court has shown, it can act pretty quickly when it has these immigration issues before it, and its emergency docket has been clogged.
So let me ask about kind of the yin and yang of this. If the court does not grant the administration's request, could it lead to inconsistent, even chaotic patchwork where Trump could enforce his agenda in some places but not others? So Amanda Frost, who's a University of Virginia law professor, said, without nationwide injunctions, Trump will win by losing because he can lose cases again and again and still implement his policies for most people most of the time. And she gave another example. She says if he could deport anyone he wants to for the next year and says he can't get them back, then he's accomplished most of his goal, even as the Supreme Court eventually says he can't legally do it. Is she on target?
Yeah, not really. She overstated the case. First of all, a case goes before a district court who decides the issue, usually on an early preliminary injunction, temporary restraining order. That goes up to the appellate court. And all of a sudden, everybody that's in that circuit is aware of what the appellate court decides. And therefore, it becomes uniform throughout that circuit. And then if that decision disagrees with another circuit, then it goes to the Supreme Court to resolve. So it's not an unusual situation. It happens in every area of the law. And it's not, there's no really reason to take the immigration issue out and treat it separately from the way every other case is handled.
All right, is that what Rick Hazen is saying? He's a prominent election law expert at UCLA's law school. He described a scenario in which Trump's effort to end automatic birthright citizenship is upheld in one circuit court, but not another, leaving people in one region of the country who are going to face consequences for that during that period, sometimes consequences that might not be undone. He says there will be real costs and disunity. Which argument holds the most water?
Yeah, I think the argument that holds the most water is that none of these things are things that cannot be undone. If somebody's birthright citizenship is denied, they will take it up on appeal. And then it will become the law of the district, and then the law of the circuit, and then finally the Supreme Court will hear that issue of birthright citizenship, and it'll be the law of the nation. The idea that there's going to be permanent damages done to people who claim birthright citizenship that can't be undone is something that I find to be untenable. I don't think that's the case. All of these issues are subject to appeal. Once the appeal goes for one side or the other, whatever's been done in the past can generally be undone.
So nothing's black and white?
Nothing's black and white. It might take a little longer. It might take more. It's going to take power out of the hands of district court judges, but it's going to put these cases into the more standard way that cases are handled throughout the United States.
All right. When Politics and Power continues, parental rights and opting out when it comes to school books. And will the Supreme Court ride to the rescue of Obamacare? That and more when Politics and Power continues. Welcome back to Politics and Power. Bruce Hamilton, along with constitutional law expert Rod Sullivan. The justices are hearing a case that could rescind no-cost preventative health care mandated under the Affordable Care Act. The court seems divided over the constitutionality of a government task force that determines what preventative health care services insurers must cover under the Affordable Care Act of 2010. Can you explain the challenge that started all of this?
Yeah, we need to warn your viewers here that we're going to have to talk about gay sex. And we're going to have to talk specifically about anal intercourse, okay? If you don't want to hear that, you need to turn your sound off because we're going to talk about it here for a little bit. What happened was that in Obamacare, there was this preventative services task force that was created, and it heard evidence that there was a drug called Truvada, which, if taken by gay men for 7 days, would enable them to engage in anal intercourse and reduce substantially the risk of AIDS. And this became a recommendation of this Preventative Services Board that was therefore challenged. Now, the case gets much duller from that point forward, because the challenge was that these officials are making policy decisions and they're not subject to executive control. The head of HHS can't really do much about what they say, and they're appointed and they can't be removed, and questions of that nature. So the Supreme Court justices were able to argue this whole case without once talking about the drug that was was at issue here. Yeah. And the arguments that were being made about the drug that was issued is, well, if we're going to cover this drug, are we going to cover birth control pills? I mean, they're preventative. We're going to cover IUDs, or we're going to cover, condoms. Is that all about required to be covered under the ACA? And the Supreme Court didn't really get to any of those messy issues. It really didn't want to talk about those issues. But it did talk about this issue about whether or not this board had too much power, or whether it was subject to the control by the president or the head of HHS. And that's the issue that really stumped them, because it's very seldom for them to hear a case at oral argument after it's been briefed by all the parties and say, do it again. And that's what they did. They heard the case, I want to say April 24th, and they came back April 26th, or just a day or so ago, and said, we want you to rebrief this issue. We want you to tell us whether or not the head of HHS can fire the members of the Preventative Services Board, reject their recommendations, and whether they have so much power that they should have been appointed by the president and confirmed by the Senate. And so that issue is not settled yet. It's going to go before the court again. I predict that what the court's going to do is say, there's nothing wrong with the Preventative Services Board the way it's constituted. What needs to be there is the ability of the HHS to say yes or no as to whether or not this is going to be a covered service or not. And so far, I mean, we talk about all preventative services, but it's really focused in on this one issue. That's what the real challenge is this one issue. Should gay men and intravenous drug users be the only ones provided prophylaxis under the ACA, or does everybody who wants to prevent any disease have their medications covered under the ACA? And that's really the nub of the factual issue here.
All right, so the court has to decide if the task force's recommendations are constitutional. Let's look at both arguments before the court. The administration, Trump administration, defends the task force. It argues that members are supervised by the HHS secretary, who is Senate confirmed and can effectively override any of the group's decisions. The administration defends the task force, arguing that, as I said, they're Senate confirmed and can go ahead and do that. We'll get to the public health group's argument in just a second. Am I on target with that?
Yeah.
Okay, so the public health groups say a decision striking down the task force could deeply affect the long-term health of Americans and disease prevention efforts. Insurers worry that it could inject instability into the insurance market, while hospital groups fear they may have to shoulder more of the burden from people who are sicker. A question of accountability, then, is the basis for their argument?
Yeah, it really is. It is. How much power does this Preventative Services Board have? If they are just one of the other myriad advisory boards out there that make recommendations to the head of HHS, and HHS can accept or reject the recommendations and hire or fire those members, then I think, and that's apparently where I think this is going, because the Supreme Court seemed to say, look, we're not going to deconstitute this board unless we have really good evidence of it. And so come back to us and tell us what power HHS has over this board. And that's what the new briefing is going to be about. So yeah, I mean, and the Trump administration basically, as you said, came forward and said, hey, there's nothing wrong with the board. Okay to have a board that has gives professional opinions on preventative services. The real question is, do we have to accept those recommendations?
All right, so the court's apparently split. 3 liberal justices appear ready to uphold the task force's authority. The conservatives sympathetic to the challengers. So where the court may rule on this is a toss-up.
Yeah, I don't know. Again, I will make a prediction that the board will continue to survive, but that the ruling will be nothing in the statute says that their recommendations are, law. That have to be accepted by the president, by HHS. And I think that's probably the compromise position where they'll come down.
No, there's another interesting factor here, and that's that Chief Justice John Roberts was relatively quiet during the debate. And that's interesting because he voted to save the Affordable Care Act from a variety of challenges over the past 15 years.
Yeah, he did. And even the other justices were basically of the opinion that we just want to know more about what powers this board has. And Justice Roberts, yeah, he did not ask many questions during this debate. Justice Jackson and Justice Kagan were sort of leading the charge for saying we shouldn't do anything. The other justices were leaning back and saying, well, you really haven't given us the information we need to decide this issue, and give us more information, rebrief this case, come back to us.
All right. The court also agreed to take on a new culture war and a dispute whether the nation's first publicly funded religious charter school should be allowed to open in Oklahoma. They'll review an Oklahoma Supreme Court decision that invalidated a state board's approval of an application by the Catholic Church in Oklahoma to open a charter school. Background here.
Did you know that there was a patron saint of the internet?
I did not.
I did not either.
But it's 2025.
Yeah. Saint Isidore of Seville died in 1646, long before the internet was ever created. Pope John Paul II said, well, the internet's a big device and it's new and everything. We need a patron saint for it. So we're going to appoint this saint who died, 1,400 years ago, as the patron saint of the internet. Okay, so that's what this school was named. And the Oklahoma Catholic School Diocese came to the Oklahoma Charter School Board and said, we want to open our own charter school.
And it's a virtual school, I should point out.
Oh, that's right. That's where the internet comes in. This is a virtual school serving about 500 students. And basically, the charter of the school says we are going to teach our school according to Catholic principles. You don't have to be a Catholic to, attend. You don't have to worship as a Catholic. You don't need to believe in Catholicism, but we're going to teach it in the school. And so the Oklahoma Attorney General took the case up to the Oklahoma Supreme Court, and the Oklahoma Supreme Court said, nope, that's a bridge too far. You're establishing the Catholic Church by paying for a Catholic parochial school that will teach Catholic principles. And the Oklahoma Attorney General said, hey, look, I sent my kid to a religious private school, but I paid for that. You can't do it if they're using tax dollars. And so this is the issue that's going to go up to the Supreme Court. The issue has been kicked about by similar issues have been kicked about by the Supreme Court probably for the last 13 or 15 years. For example, one government entity said that a school district, a Catholic school, could not get playground equipment to use on their playground because that would be the establishment of a church. And the Supreme Court said, no, if you're giving playground equipment to all the schools out there, the fact that this is a Catholic school does not promote religion, and therefore you got to treat them the same. My own feeling is this might be a step too far, because this school is providing instruction in Catholicism, and therefore that could literally violate the First Amendment's Establishment Clause, providing money to a church-run school. But you know, who knows? They took the case up on appeal. They usually are not going to take the case up on appeal to pat the Oklahoma Supreme Court on the back and say, yeah, you did right. So there's that, suggestion that maybe they're going to refine or actually reverse the Oklahoma Supreme Court. But the greater weight of authority seems to be that you can provide certain benefits. You can provide school buses, you can provide textbooks, you can provide playground equipment. But when you're supporting a school that actually teaches a faith, that may go beyond the pale. We'll see. They're arguing it tomorrow.
Yeah.
We'll know what their questions are.
Which would be April 30th because of when we're doing this show. Let's look at the two arguments. Oklahoma's former governor, Frank Keating, wrote in the court's majority opinion, under Oklahoma law, a charter school is a public school. As such, a charter school must be non-sectarian. However, St. Isidore will evangelize the Catholic school curriculum while sponsored by the state. Those who dissented said excluding St. Isidore from operating a charter school based solely on its religious affiliation would violate a different part of the First Amendment that protects religious freedom. Now, the conservative-dominated High Court has issued several decisions in recent years signaling a willingness to allow public funds to flow to religious entities. And at the same time, conservative-led states have sought to insert religion into public schools. So we can include Louisiana's requirement that the Ten Commandments be posted in classrooms. Does that offer a clue where the court ruling might land?
I think it does. And I think where the governor went wrong is the question about whether the Catholic Church is being excluded from participating solely because they're Catholic. And I don't think that's the issue. I think the issue is that the Catholic school curriculum said, we are going to teach Catholic principles to our students. And that's probably what crosses the line. So the Supreme Court could come back, for example, a compromise decision, and say, if you're excluding them just because they're a Catholic institution and you're providing it to other institutions, that violates freedom of religion. But if you're going to require them to separate out their religious instruction from their secular instruction, that's probably going to be okay. And so I think that's where the court may sort of revise this issue, may massage the issue.
And is the court's consideration also, so if we allow the funding to this religious school, it would have an impact on other charter schools nationwide?
No question. You're going to see, if they allow it, you're going to see other religions seek to have charter schools, and that may be the compromise decision. You can have a Muslim charter school as long as you're not teaching Muslim theology. You can have a Judaic school as long as you're not teaching Judaism. If the money is going to support education that is non-sectarian, probably be okay. I think if this school was not so upfront in saying we're going to be teaching Catholic education, Catholic principles, that probably is what made their case harder for them.
For Chief Justice Roberts, mindful of his legacy, I think he has a lot on his plate.
Oh, there are so many cases. It's difficult for me as a professional to keep up with all of the oral arguments and all the briefs that come. I can't keep up with all the briefs. There's just too many of them. But I do the best I can. But if I'm having trouble keeping up, I can imagine how a Supreme Court justice who is getting petitions on a Sunday afternoon that he has to decide by Sunday at midnight, what kind of problems they're having.
And he probably has to juggle more political balls than he cares to.
Yeah, I thought this was going to be a quieter Supreme Court, because last year we had a lot of issues before the court, but this year it's even more. It's even more difficult to keep up.
And probably the fact that it plays out more publicly than in the past is not helping things.
Yeah, I mean, let's just go back to the immigration issue. Obama deported 3 million people, and you never heard about it in the courts. Biden brought that down to 650,000, so less than one-fifth of what Obama did, and you didn't hear about that before the courts. Trump deports 150 to 300 Tren de Aragua members, and it's on the news every single night. And so, yes, there's a lot more coverage of it. There's a lot more interest in it.
Rod, always a pleasure to have you here and offer your context, perspective, and focus.
Enjoy it.
We'll have you back again soon.
All right.
Because I'm sure there'll be more hot-button issues before the Supreme Court.
We'll do what we can.
Appreciate you watching. Remember, you can watch anytime on demand on the News4JAX YouTube channel and News4JAX.com. Have a great day.
See why every day more people are choosing News4JAX, Northeast Florida and South Georgia's #1 source for local news.